Please be seated. The court is now back in session. And again, the floor will be given to Nguyen Chia to make his final statement. You may now continue. Nguyen Chia. The issue of evacuation. As I have testified before the Chamber during the last couple of years, after the liberation on 17 April 1975, all city dwellers were indeed evacuated out of the cities. However, it was not a forced evacuation. There were two main reasons that leaders decided to rely upon in so doing. First, it was the fear of American bombardment on the cities after the Tribunal government was defeated. And this was one reason that the leadership and Cambodian people believed. They believed that the United States would renew its bombardment in many cities, and especially in Phnom Penh. They believed that because the United States had previously dropped several tons of bombs in Cambodia. The second reason was that war had been waged in Cambodia for over 5 years. Through this experience of war, Cambodia faced many challenges, including food shortage. And food shortage was a main problem that needed to be resolved urgently, as it was related to the life of people. At that time, Cambodia did not receive any foreign aid or assistance. Facing such pressing circumstances, the CPK leadership devised a plan to evacuate people to regions and provinces where they were rich in economic resources, husk and unhusked rice, that could feed the evacuated people. In turn, they would be required to join in the production activity for self-sufficiency and country reconstruction. In relation to evacuating people from Phnom Penh city, the Standing Committee instructed the Central Committee to convene a meeting to prepare for evacuation. All members of the Central Committee attended that meeting, and I recall that the Northwest Zone agreed to receive 1.5 million evacuees. The East, the Southwest, and the Central Zones agreed to take the rest of the evacuees. For the plan implementation, each zone had the autonomy to coordinate amongst themselves to facilitate the evacuation. They had to provide instructions to cooperatives to assist the evacuees from Phnom Penh without any discrimination against them. With the two reasons, the evacuation proceeded on a voluntary basis without coercion, violence, or any killing. It was implemented via clear information being explained to the people to understand the risk of being bombarded by the United States on cities and the need to resolve the living condition of the people and self-construction of the country. At that time, people understood the dangerous situation and the pressing need for the country. Especially people supported and loved the revolution. Gradually, people left the cities in accordance with the explanation and appealed by the CPK. Regarding this point, I would like to respond to the co-prosecutor's argument. They allege that the CPK surrounded Phnom Penh city and that led to food shortage. They also allege that shelling Lon Nol's military bases in the city was an inhumane act. However, the co-prosecutors failed to mention that Lon Nol soldiers, equipped with artillery provided by the United States, emptied many millions of shells, and together with more than 500,000 tons of bombs dropped by the United States, they devastated the country as houses, properties, animals, and farms were destroyed. Especially tens of thousands of people were killed, including the elderly, children, and women. Isn't this an inhumane act or a crime? The bombs that the United States dropped on Cambodia were 3 times more than those dropped on Japan during the Second World War. The CPK also considered Phnom Penh city dwellers, my apology, the CPK did not regard the city dwellers as enemies, contrary to the allegation made by the prosecution. On the other hand, those Phnom Penh city dwellers were mostly workers, peasants, petty bourgeoisie, and intellectuals, whom the CPK needed to gather their forces and strength in order to build the revolution. I also would like to respond to the co-prosecutor's allegation that the DK regime was a slave state. It is simply not true. I would like to inform my compatriots that CPK did not struggle to liberate the country for the purpose of transforming its people into slavery as alleged. On the contrary, the CPK liberated the people from slavery. We all should have known that before the liberation on 17 April 1975, majority of the peasants were poor, could not support themselves on a daily basis, and faced grave difficulty in their living condition. The local authority at the time failed to provide a proper public service and social welfare to the poor people. Corruption was ripe and injustice rooted deeply in Cambodian society. This resulted in people becoming poorer and poorer. Poor people needed to borrow money from the rich in order to support their living, for medical treatment, and to pay tax. That was the time the rich exploited the situation. They persecuted the poor, they demanded interest as they pleased, and monthly interest could skyrocket as much as 50% of the capital. As a result of this excessive interest rate, people could no longer afford to pay their debt, and creditors confiscated farms, rice paddy, and houses. And when they no longer had any farm, rice paddy, or house, they were forced to work as slaves in order to pay debt that was never ended. In many instances, they were forced to sell their children to work for others and became their slaves merely in exchange for food. This exploitation and the poorness of these people was one of the many causes that the CPK determined to resolve by liberating the nation and people from slavery, from human exploitation and invasion by other countries, by building a country where people could live equally and own the country with independence, self-mastery, self-reliance, and decide own destiny and nation. The CPK did not design any policy or plan to have its people placed in slavery by food deprivation, forced labor, or killing. On the contrary, in mid-1976, the Standing Committee prepared and adopted the 4-year planning to build socialism in all fields. The CPK line and policy was to promote the livelihood of the people. This plan set forth a food regime for people, that is, each person would receive certain tang, or 312 kilograms of rice per year. So people would have enough food, and they could have 3 to 4 meals per day, with 2 courses, a soup and a fried dish. In addition, additional food and dessert would be provided every 3 days. In 1977, and every 2 days in 1978, and every day from 1979 onwards. As for work hours, people would be allowed to work 8 hours per day and will be entitled to 3 days off per month. Pregnant women will be allowed a 2-month maternity leave after delivery. Sick people could rest depending on actual condition. In addition, we prepared to increase machinery to reduce physical workload of the people. This shows that the CPK stance was not to force people to work hard. I recall that one day I traveled through Siem Reap province via Kampong Thom at night. I saw people walk through the rice fields, and I asked local cadres about this, and I was told that people had high commitment to work extra hours. Only after 1979 did I learn that local cadres lied to me. Concerning healthcare, the CPK prepared a 4-year planning for medicine with a total amount of $35,270,000. The 4-year expenditure for clothing was $66,270,000. For housing, hygiene and culture, the 4-year expenditure was $80,230,000. The CPK clearly and specifically set out these plans for zones and autonomous sectors to implement it. The CPK did not design any plan or policy to kill people. On the contrary, it had planned to increase population and not to reduce it. However, it is so regretful that zones and autonomous sectors did not implement the Standing Committee's decision. Up to now, I can conclude and respond to questions put forth by the court and especially by the public that the strategic events that happened during the DK period were caused by the following reasons. 1. The CPK made incorrect decision to recruit some cadres as they betrayed. They did not grasp well the party line, and some leaders occupied themselves with works in Phnom Penh and failed to visit cooperatives regularly. 2. Some zone and autonomous sector leaders and cadres were Vietnamese and American infiltrated agents who betrayed the revolution. They carried out activities to destroy the CPK movement, the people, and the country of Cambodia. They did not follow the CPK policy and instructions. Instead, they killed and mistreated people by starving them and arbitrarily engaging them in forced labor. They concealed these facts and fabricated reports to the party Central Committee. They resorted to all kinds of methods to make people upset with and turn against the revolution. This weakened the revolution and made it vulnerable to enemy's invasion under the pretext to liberate the people, thus legitimize its invasion. As a matter of fact, the East Zone leaders deprived people of food and secretly exported rice to Vietnam. They were the one who seemed to burn the outer skin crisp while leaving the inside raw. They excessively implemented the CPK policy. The phrase "they left the inside raw" infers that they did not engage in anything at all, but left their lower cadres do whatever they pleased. 3. A large number of cadres at zone, autonomous sector, district and cooperative level failed to sufficiently grasp the CPK line, planning and policy. They failed to report the situation concerning hardship and shortage faced by the people. Instead, they falsified their reports to the party center by boasting about their achievement and success in leading their respective base. And to achieve what they fabricated in the reports, they resorted to forcing people to overwork, reducing their food ration, and killing them arbitrarily. In summary, the CPK had clear reasons for the evacuation of people. The evacuation was to ensure their safety and to liberate them from slavery and injustice. It was never meant to place them in slavery. On the issue of fair trial, Your Honours, it is my observation throughout this proceeding that some of my fundamental rights have been violated. Actually, I would not say the trial is, because I am asking the court to find justice for me. And if the chamber is upset because of my criticism, then the injustice indeed falls upon me. However, if I don't raise the issue of my rights being violated, the chance to find justice for me is even slimmer, as those rights are fundamental to seeking my justice. Concerning this point, I have carefully followed and observed the court's proceedings, and I submit that my many rights have been violated. Namely, 1. Inequality of arms in collecting evidence. Throughout the proceedings, my counsels were not allowed to conduct any investigation for the purpose of collecting evidence for my defense. However, the co-prosecutors had ample opportunity to conduct their own investigation since the beginning. My counsels were not allowed to seek for other witnesses, except those whose names are on the co-investigating judge's list. This apparently tied my counsel's arms and restricted them from gathering evidence for my defense, while the other side was afforded full opportunity to attack me freely. This has severely affected my defense team and my legitimate interest. 2. Failure to summons important witnesses. My defense counsels repeatedly requested the chamber to summons some important witnesses to testify before this chamber, namely character witnesses and Tulpujray witnesses. However, the chamber denied such request. Such decisions have seriously impacted the process of ascertaining the truth in this case. 3. Bias in examination of witnesses before the chamber. The examination of witnesses is an important process in ascertaining the truth and clarify some uncertainties regarding some witnesses. Your Honors are to rely upon these testimonies when you make your just decision. In this chamber, I can see that Your Honors have failed to consider this issue properly. During the prosecution's examination of witnesses, Your Honors always afforded them the opportunity with minimal interruption, despite objections raised by the defense. The defense lawyers, however, were not that lucky, as they were not allowed such opportunity. They were interrupted most of the time by the objections from the prosecution, and Your Honors always agreed with the prosecutor's objections. And sometimes when the defense lawyers raised their objections, instead of being sustained, they were overruled and they received warnings from the president of the chamber. As we could see, the unequal treatment, Kirsampon and I decided to no longer testify before the chamber anymore, because we thought that, to Your Honors, our testimonies mean nothing, as you are clearly biased, and the proceedings that have been conducted in this chamber are just for the sake of completing the procedure or making it look good in the eye of the public. In conclusion, based on the three grounds that I have stated above, it clearly shows that I did not carry out any plan to commit the crimes. I did not provide any support or encourage anyone to commit the crimes. Despite the fact that I had a role as Deputy Secretary of the CPK and President of the People's Representative Assembly, I did not have any knowledge of the crimes committed at the base level. Only toward the end of the decay period had I learned the treacherous acts committed by leaders at some zones, sectors, and bases. They had intention to destroy the CPK movement, and at that time I did not have any effective authority to prevent those treacherous acts. Nor had I any role in controlling the armed forces or local authorities. If I had any authority to lead or commit the alleged crimes during the decay period, surely the court that was established in 1979 by the People's Republic of Cambodia would have prosecuted and convicted me like Pol Pot and Ieng Sary. Evidence of those crimes at the time was still fresh, and apparently there is no need to wait for 38 years to try me. However, they knew that I had no authority and did not commit any crime. Nonetheless, I would like to express my deepest remorse and moral responsibility to all victims and Cambodian people who suffered during the Democratic Cambodia regime. As a matter of historical fact, the CPK's policy, line, and plan were solely designed for one purpose and one purpose only, that is, to liberate the country and people from colonization, imperialism, exploitation, extreme poverty, interfering and invasion by neighboring countries, especially by Vietnam. The CPK's policy was clear and specific. It wanted to create an equal society where people are the masters of their country for the purpose of independence, self-mastery, self-reliance, and deciding its own destiny and nation. The CPK movement was not designed for killing people or destroying the country. My conscience, my hope and wishes were destroyed by those who betrayed the movement. My people suffered and killed. My nation fell apart. Although the tragedy in the decay period was the result of the acts committed by those traitors, in the name of Deputy Secretary of the party that had the responsibility to disseminate and propagandize education about the CPK policy, I would like to sincerely apologize to the public, to the victims, their families, and all Cambodian people. And I still stand by my previously stated position that I am morally responsible for the loose and untidy control by the CPK. I wish to show my respect and pray for the lost souls that occurred by any means during the Democratic Cambodia period. In short, through this trial, I can see that justice is circumstantial. However, the reality remains unchanged forever. Black cloud can never cover the entire sunlight. Likewise, bad and immoral people cannot tell lies and hide the reality from the eye of the people and the popular masses forever. They cannot hide the reality of courageous struggle by the Cambodian people and the support afforded to them by the people in the world who loved peace and justice. Therefore, Your Honors, based on the evidence and reasons I have stated above, and especially the closing statements made by my defense team, I respectfully submit to Your Honors to acquit me from all the charges and accordingly release me. I am grateful to Your Honors. President, thank you. Security guards, please bring the accused back into where he sat earlier. President, the Chamber would like now to give the floor to Nunchi's counsel to make your final rebuttal statement. You may proceed.
Mr. President, Your Honors, good morning. Council, civil parties, everybody in the public gallery. Mr. President, yesterday I indicated that I would speak for 30 minutes, but having heard afterwards that the Khieu Samphan team will use only 1 hour of its time, I would hope that the Chamber would allow me to speak 15 or 20 minutes extra in my rebuttal to the submissions yesterday of the prosecution. Nevertheless, Mr. President, I will try to be as brief as possible and try to respond directly to the arguments of the prosecution and the civil parties. And in general, I would like to address the arguments advanced by each counsel. And although I may by necessity move around because of the overlap between the various counsels' arguments. Mr. President, Your Honours, let me begin by addressing the comments advanced yesterday by the civil parties. The first observation I will make concerns the civil parties' parroting of the OCP's phrase, slave state. We have heard this catchphrase now many times. And like an advertising campaign, the civil parties and the prosecution have flashed it in our faces like a neon sign, all in an attempt to argue that it epitomized the common purpose of the CPK. As we have expressed in both our brief and in oral argument, the use of this slogan, the slogan of slave state, is not correct and is in fact misleading. Not just because of its inaccuracy in describing the workings of the CPK, but also because it is based on evidence that is not at issue before this chamber. What do I mean when I say that this is not at issue before this chamber? I mean that it is grounded in witness statements and evidence that are outside the scope of case 002/01. Mr. President, this trial, as we are all well aware, concerns two population movements and the alleged Tulpo Che crime site. Cooperatives and their corresponding conditions are not a part of this trial. Despite this, the prosecution and civil parties have tried to backdoor witness statements recounting cooperative conditions to show that certain individuals were treated like slaves. Having failed to use this phrase in their closing briefs, the civil parties, following the prosecution almost blindly, now do the same. Mr. President, Your Honours, it cannot be stated more explicitly. All of the witness statements alleging individuals in cooperatives were subjected to slave-like conditions are outside the scope of case 002/01. We have not been able to examine them or test their relevance or reliability. Civil parties and the prosecution have made no effort to show whether these statements, based entirely on witness observations of conditions on the ground, are in any way remotely representative of the country as a whole. By using the slave state slogan, the prosecution and civil parties have tried to have their proverbial cake and eat it too. They have conjured a sensational and evocative tagline to advance their allegations, all the while keeping the evidence underlying it safe from scrutiny. As it is based on evidence that is not part of this trial, its relevance and
The President, Mr. Nunchia, you may... please hold on, Mr. Nunchia has something to say. Mr. Nunchia, you may proceed. The President, Mr. Nunchia, you want to be returned to the holding cell downstairs? You may leave the courtroom. Security guards are now instructed to bring Mr. Nunchia to the holding cell downstairs. Mr. Kope, you may now resume your statement.
Thank you, Mr. President. As I said earlier, by using the slave state slogan, the prosecution and civil parties have tried to have their cake and eat it too. They have conjured a sensational and evocative tagline to advance their allegation, all the while keeping the evidence underlying it safe from scrutiny. As it is based on evidence that is not part of this trial, its relevance and substance remain untested by the defense. Indeed, the defense itself requested this evidence be included in this trial, a request that the prosecution objected to, underscoring their fear that they did not want to risk exposing these allegations to the light of day. And Mr. President, the civil parties have applied this tactic in other ways. We can see it, for instance, in their claim that 2 million deaths occurred during the democratic Kampuchea period. This allegation of 2 million deaths is again based on untested evidence. Why? Because the report it is based on is not part of this trial. It has not been examined by the parties. The demographer who created it has not been called here in this courtroom as an expert witness. Why? Again, Mr. President, the answer is simple. Because the total number of deaths alleged during democratic Kampuchea is not a part of this trial. Could it be that both the civil parties and the prosecution are suffering from acute amnesia when faced with the charges at issue in case 002/01? Have they somewhat conveniently forgotten that this case only concerns 2 population movements and 2 portray? While I could sympathize with the symptoms of a failing memory, even this explanation seems too generous. Whatever their excuse may be, Mr. President, the trial chamber cannot condone this mode of proceeding. Allowing the prosecution and the civil parties to base claims on untested evidence outside the scope of this trial violates basic principles of the right to a fair trial. And the chamber must accordingly give such assertions no weight whatsoever. What I would like to call sensationalizing of witness statements has not been limited to outside the scope of the trial. Evidence within the scope of case 002/01 has been treated by the civil parties and the prosecution in the same manner. Examples of this are seen in the civil parties' use of allegations that Khmer Rouge cadre killed babies and people with glasses. These witness allegations cannot be used as the poster children for democratic Kampuchea. The reality is that these claims are unrepresentative of the experiences of individuals during democratic Kampuchea. Their misuse in describing a policy of the Khmer Rouge is therefore disingenuous, and it must be disregarded. Now, Your Honours, I would like to pause for a moment and reflect on the allegation made by the civil parties yesterday morning that in defending our client, we have somehow made a mockery of the civil parties. This is unwarranted. The defense has never denied the suffering of the civil parties. We have never called them liars. In fact, we offer the utmost sympathy to their suffering. We have, as we are tasked with doing as defense attorneys, made very precise claims challenging the evidence against our client. If the civil parties cannot appreciate this distinction, it reveals on their part, we would say, a serious misunderstanding about the role of a defense attorney. In their rebuttal yesterday, the civil parties attempted to paint a picture that the defense has put forward an entirely unrepresentative image of the CPK. An image, they say, that is not supported by the evidence. They have cited to various references in our closing brief in an attempt to show that our assertions are outside the scope of the realities of democratic Kampuchea. They point to our use of language to further this argument, labeling such words as evacuation and liberation as prime examples of what they call Orwellian newspeak. To this, Your Honours, we simply remind that parties that these terms are used continually by all the parties throughout the courses of this trial. These terms, Mr. President, are taken straight from the closing order itself. And we can only speculate that if the lawyer for the civil parties had perhaps read the closing order with more care, such terms as evacuation or liberation may not have come as such a surprise. In contrast, while the civil parties coined phrases like after liberation straight to the killing fields, we have remained measured in our use of language. Finally, Mr. President, it is with irony that the defense addresses the final claim of the civil parties, that the defense is guilty of misrepresenting the evidence to suit our own narrative. Specifically, the civil parties attack our use of witness Lei Boni's testimony that the physical conditions of evacuees during the second population movement was both good and normal. The civil parties proclaim that, and I quote, if the defense had read but 4 lines more, unquote, of Lei Boni's testimony, it would have been apparent that Lei Boni also testified that the evacuees had swollen bodies and that they received less food than pigs. Mr. President, Your Honours, the defense did in fact read those additional lines of testimony and noted that those lines did not address the second population movement, but instead referenced conditions after resettlement in cooperatives in Pursat. To the conditions in the new cooperatives, Lei Boni observed, and I quote, that however when time passed by, we did not have enough food to eat. We ate a food that was very little. We ate food that made us become, our body parts become swollen. And we believed, at that time, we noted that the pigs were even given more food than they gave to human beings. End of quote. Your Honours, I now turn to the co-prosecutor's submissions concerning our arguments about the fairness of this trial. The co-prosecutors, in an attempt to gloss over these violations, advanced the argument that in allowing the defense their 2 allocated days of oral argument, the Chamber somehow showed its commitment to the fair trial rights of our client. The co-prosecutors seem to suggest that in granting us this time, all the fair trial violations have been absolved. To this statement, we can only ask, is the standard that low? And it seems, Your Honours, that the answer to that question is yes. As the Chamber knows, the most important of these fair trial violations concerns witness Heng Samrin, the witness at the heart of our fair trial argument, whose presence at this trial we called earlier a non-negotiable bare minimum for securing a fair proceeding. Heng Samrin, who is a witness of paramount importance to the charges at issue at this trial, the evacuation of Phnom Penh, the events at Tulpo Tray, and the alleged policy to kill former Lon Nol soldiers and officials. Heng Samrin, a witness in possession of important exculpatory evidence that directly exonerates our client from the allegation that he had intended the killing of former Lon Nol soldiers and officials. Heng Samrin, the one and only character witness requested by Nguyen Chia. Your Honours, everyone in and around this courtroom must ask themselves this question. What have you heard from the co-prosecutors and the civil parties in reference to the failure of the chamber to summons Heng Samrin? Nothing. Absolute silence. The co-prosecutors and the civil parties have not responded to the substance of our complaint at all. And there are numerous arguments the parties could have made regarding our request to call Heng Samrin during this trial, but nothing has been said. For instance, they could have argued that the evidence Heng Samrin had to offer was not important, or that it was evidence that could have been established by different witnesses. They could have argued that evidence of Nguyen Chia's character was not relevant, or argued that there were other higher-ranking military witnesses that could have been heard. They could have attempted to argue there was already sufficient evidence of Nguyen Chia's intent and that Heng Samrin's testimony was therefore not needed. But did they make any of these claims? No, they did not. Mr. President, Your Honours, Heng Samrin is the elephant in the room that the co-prosecutors and the civil parties dare not speak of. Why is it that they are rendered mute by this man? Why not talk about it like Craig Edgerton did this morning in the Phnom Penh Post? We can think of two reasons only. They either agree that his presence is of paramount importance and a fair trial cannot be had without his testimony, or they are simply not allowed to even mention his name. Either one, Your Honours, would be a remarkable position about these proceedings. If the answer is that the parties cannot even discuss the nature and degree of this fair trial violation, then the extent to which the co-prosecutors remain in the government's clutches is even worse than we thought. If the answer is that a fair trial is impossible without his presence, then we have confirmation from all parties that our client's fair trial rights have been irreparably harmed. The international co-prosecutor, Mr. Kumijan, also addressed our argument that this trial is fundamentally political. We heard him say yesterday that he denies that claim. He says that this trial is not about politics, but about law. Mr. President, we disagree. We have submitted that a proceeding such as this could never separate law from politics. That a tribunal such as this infuses law with politics. And let it be clear, this view is not constructed from thin air. It is not woven in the minds of a paranoid defense lawyer. It is a viewpoint with a long pedigree in the history of international criminal proceedings. The Indian judge, Justice Paul, gave serious consideration in his dissenting opinion at the Tokyo Tribunal to the question of whether victors of a war can fairly judge its losers. And respected academics did the same. Nguyen Chia's view that he cannot be fairly judged by representatives of the two principal victors is a serious argument that deserves serious reflection. And if this trial is about law and facts and not politics, why do the prosecutors so consistently ignore facts that are legally relevant to the charges? Mr. Lysak informed this chamber yesterday that the co-prosecutor's final brief included 40 pages of historical analysis. But the question is, which history? Why does it describe the CPK's alleged violence prior to 1975 with almost no mention of the American bombing? Or of the atrocities committed by Lon Nol's forces against CPK cadres? Was the CPK fighting a war against a phantom, or was it fighting a war against an enemy? Does anyone doubt that the intent of the CPK's alleged policies against enemies changes radically in light of the ruthlessness of the enemy it was actually fighting? Nor are more powerful actors equally responsible for conduct identical to that for which our client stands charged, accused of identical crimes. Do the co-prosecutors dare accuse the people who run this country, the people responsible for implementing our client's policies? Mr. President, Your Honours, the answer to this question is of course no. The answer is that the prosecutors who claim this trial has nothing to do with politics cannot even bring themselves to say Heng Samrin's name. They cannot even bring themselves to contest the defense claim that the trial and the investigation were unfair. Let me now, Mr. President, turn to the crimes which were discussed jointly by Mr. Rayner and Mr. Lysak. And I will begin with the evacuation of Phnom Penh. With regard to the evacuation of Phnom Penh, I would simply like to clarify a serious misunderstanding of our oral argument which became apparent yesterday and which may have caused some confusion during our client's speech here this morning. As our brief explains, and our client repeated again here in this morning, the evacuation of Phnom Penh was driven by a variety of considerations. These included the food supply within Phnom Penh and Cambodia more generally, the effects of the US bombing, and the state of Cambodia's economic infrastructure, including its rice paddies as of 17 April 1975. Our submissions before the investigating judges and this chamber consistently emphasize all of these factors as integral to the decision to evacuate and the manner in which it was carried out. Yesterday, the co-prosecutors seized on a single sentence in my Cambodian colleague's remarks from last week to the effect that the evacuation would still have been carried out had the food crisis in Phnom Penh not existed. The prosecutors argued that this sentence amounts to a concession that neither the American bombing nor the food supply were relevant to the forced transfer charges. Now, Mr. President, that of course was a misstatement of our position and of reality. Those facts are critically relevant now, as they have always been, to Nguyen Chia's defense. First, as Sonarun explained, the bombing devastated Cambodia's economic infrastructure and its ability to produce food. That reality was a fundamental aspect of the CPK's conclusion that the economy could not support unproductive cities in a society in which economic production was driven entirely by the rice paddies. Second, as Sonarun also explained, the evacuation would have looked very different had an impending catastrophe of starvation not existed. During yesterday's hearing, as they have throughout this trial, the co-prosecutors repeatedly attacked the evacuation not for the fact that it happened, but for the way it happened, including its immediacy and the fact that it affected all of the residents of Phnom Penh. But those are precisely the features of the evacuation which were driven by the threat of imminent starvation, including the fact that 6 days' worth of food remained in the city on 17 April 1975. So, Mr. President, the arguments that you heard yesterday, which implied that we had somehow abandoned the food supply and US bombing arguments, were misguided. My final remark about the evacuation of Phnom Penh is that both the civil parties and the co-prosecutors again make the claim that Nguyen Chia did not subject himself to cross-examination. Nguyen Chia subjected himself to 12 days of cross-examination, some of which was described by Mr. Lysak yesterday. And he refused to continue only because of the violations of his right to challenge the evidence against him during the appearance of Mr. Steve Hedder. So, Mr. President, Your Honours, hopefully we can put to rest this myth that our client refused to testify about the evacuation. I would like to turn now to certain comments made by the co-prosecutors concerning the second population movement. While addressing the second population movement, the co-prosecutors misconstrued our argument, claiming that we had said that the second transfer was implemented by rogue zonal leaders, that the second transfer was in fact a rogue operation. We have never said it was rogue. This portrayal of the second movement is their formulation, and it is nonsense. Mr. President, our point was, and still is, that the second movement was the prerogative of the zones. That both Ros Nim and Sao Pim, leaders of the two zones allegedly instrumental in the second population movement, were not mere zone leaders, but powerful members of the Standing Committee. As a matter of fact, founding members of the CPK, and at least equally as powerful as Nguyen Chia and Pol Pot. And that the evidence before this chamber supports the conclusion that it was the zones that had primary control and authority over the second population movement. Next, Mr. President, I will turn to Tu Po Tray. We have many things to say about Tu Po Tray and its underlying policy. But because of the time, I will limit myself to 6 key points. First, the co-prosecutors yesterday simply say nothing about any of the direct evidence that no policy of executing Lon Nol soldiers and officials existed. They say nothing about Pi Pun. They say nothing about Heng Samrin. They say nothing about Uk Bun Chun. They do not challenge it. They do not contest it. They do not tell the chamber that it is unreliable. They also do not tell the chamber how to resolve the direct contradiction between their position and this clear evidence from well-placed CPK insiders. As I have already observed, we claim that there was a violation of our client's right to a fair trial so serious that it required dismissal of all charges concerning Tu Po Tray. And again, the co-prosecutors did not even mention it. And that is, we submit, remarkable, to say the least. Second, Mr. President, the co-prosecutors offered this chamber 2 pieces of evidence that a policy to execute Lon Nol soldiers and officials existed. The first piece of evidence was a photo of a group of people at the Ministry of Information, supposedly on 17 April 1975. Now, Mr. President, Your Honours, I would like to show that photo on the screen. And with your permission, Mr. President, I would like to do that now. And maybe to the AV unit we could show it a few times in a row, because it's part of a little video.
President, you may proceed.
Establishment. Moments after this photograph is taken, this group of MPs and bureaucrats are led to a nearby tennis court and massacred. To round up and execute all those who were linked to the Lon Nol establishment. Moments.
Excuse me, Mr. President. The co-prosecutors called this photo of some people calmly standing around with their arms folded, and I quote, very strong evidence that every soldier and every official of the Khmer Republic who was killed in all of Cambodia on or around 17 April 1975 was in fact killed pursuant to a CPK policy. This photo, Mr. President, was one of the two pieces of evidence that the co-prosecutors claim conclusively proves the existence of that policy. Now, maybe the co-prosecutors see a secret code in this photo that we do not. And contrary to the co-prosecutors' claims, we responded to this evidence directly in our oral argument last week. We conceded that the people depicted in this photo were present at the Ministry of Information, which is all that this photo shows. We explained why that fact is irrelevant to any supposed execution policy. Co-prosecutors chose not to respond to those arguments. Instead, they just reiterate the fact that these people were present at the Ministry of Information. And this supposedly very strong evidence, Mr. President, is irrelevant. The second piece of supposedly conclusive evidence was a series of quotations from Duik. As we have argued before, Duik has admitted to having had no basis to make any conclusions with regard to CPK policy. His testimony is irrelevant. However, I will add that even the irrelevant excerpts cited by the co-prosecutors yesterday establish that no execution policy existed. Yesterday, the prosecution quoted Duik saying, and I quote, "During that initial stage, people were evacuated and then some of the senior soldiers were arrested and secretly killed." End of quote. We do not know how Duik came to this conclusion. But even this evidence suggests that only senior soldiers were apparently executed. And even then, that only some of those senior soldiers were executed. And the co-prosecutor's other evidence from Duik was just as inconsistent with this supposed policy. As the prosecution noted, Judge Leverne asked Duik in case 001 whether people linked to the Lon Nol regime were executed. Now, Duik's answer was as follows, and I quote, "People in Lon Nol's regime were classified into three categories. First category referred to the people who were smashed secretly." End of quote. Now, this is the point where the co-prosecutors stopped reading. But as your chamber is well aware, the excerpt continues. And I quote, "The second category referred to the people who were detained in the re-education camp. And the third category referred to the people who were regarded as the new people." End of quote. So this is the co-prosecutor's final concluding evidence of a policy of systematically hunting down and executing all Lon Nol soldiers and officials. It proves that no such policy existed. Mr. President, my third of the 6 points about to portray concerns pattern evidence. Yesterday, the co-prosecutors did not even attempt to contest our systematic demonstration that no such pattern existed. Mr. Rayner spoke very theatrically about the systematic nature of the pattern. You might remember he asked the Chamber 5 or 6 times whether it was a coincidence that killings occurred in exactly the same way across the country. And our question is this, Mr. President: is it a coincidence that the co-prosecutors failed to identify one single witness proving the existence of this pattern, which they say happened everywhere? Is it a coincidence that they failed to respond to a single one of the numerous concrete arguments we presented to the Chamber in our closing submissions? Mr. Lysak also commented on the supposed pattern evidence. He told the Chamber that the defense has, and I quote, a thesis, unquote, about the supposed execution of Lon Nol soldiers in April 1975. He said our thesis was that executions happened in the southwest and northwest zone, but not elsewhere. In reality, Mr. President, we have no quote-unquote thesis about the execution of Lon Nol soldiers. Our only thesis is that the co-prosecutors have failed manifestly and completely to establish the existence of a centrally directed policy. The reasons for that conclusions are firstly that it is inconsistent with the direct evidence, secondly that the so-called pattern evidence is systematically unreliable, and third that the systematically unreliable evidence is geographically concentrated in the southwest and northwest zone and is therefore irrelevant to statewide policy. The prosecution contests none of these facts. In order to establish the existence of a policy based on unreliable evidence, not tested in open court, which is concentrated in only a small part of the country, the prosecution should be ready before this chamber with quite an extraordinary explanation. Now, Mr. Lysak proposed a possible explanation. He suggested that maybe there were more Lon Nol soldiers in the northwest and southwest zone than elsewhere in the country. Yet at the same time, he does not offer the Chamber even a shred of evidence in support of this proposition. The evidence we showed the Chamber last week demonstrated overwhelmingly that Lon Nol soldiers were not executed in liberated zones prior to 1975. There is no reason to believe that Lon Nol soldiers did not continue living in those zones until and after April 1975. Nor does the evidence merely show that fewer Lon Nol soldiers and officials were killed in the special, central, north, the eastern, and the northeastern zones in April 1975. It shows they were not killed in those zones at all. We have adduced substantial evidence affirmatively demonstrating that Lon Nol officials who were present in the East Zone or within the control of East Zone troops were not harmed. Like Mr. Rayner, Mr. Lysak failed to say anything about the evidence. He failed to give a single reason why the analysis we presented to the Chamber last week was erroneous. He failed to refer to a single statement of a single witness. Mr. President, Mr. Lysak then suggested that a concentration of evidence in the southwest zone would be consistent with party center policy because Pol Pot had a close relationship to the southwest zone. It seems he would like this chamber to make two conclusions. He would like this chamber to conclude first that Tamok was close to Pol Pot, and second, that because Tamok was close to Pol Pot, everything that happened in the southwest zone reflected the intent of the party center. But there is no evidence to support either claim. Neither claim has been the subject of so much as 5 minutes of witness testimony. Neither claim has been the subject of a single filing. Before yesterday, neither claim had been the subject of 5 minutes of debate before the Chamber. And just last month, the co-prosecutor's position was that executions happened everywhere. Mr. President, just last week, the co-prosecutor's position was that the executions happened everywhere in Cambodia. And 5 minutes before Mr. Lysak took the floor, the co-prosecutor's position was that executions took place everywhere. Never did they try to link events in any particular part of the country with the party center. And they did not have to, because the position was that everything happened the same way everywhere. It is critical to realize that Mr. Lysak's theory would be relevant to Nguyen Chia's criminal liability only if Nguyen Chia conspired with Tamok and Rosnim, but not with Sao Pim or Ne Saran to execute Lon Nol soldiers. Now, could that theory be true? Could be true. Lots of things could be true. But the Chamber, and that is the point, has never considered it. The co-prosecutors never, before yesterday, argued it. There's no evidence at all to support it. And the Chamber has no basis on which to make that conclusion. Mr. President, my fourth of the 6 points about Tu Po Chue concerns the co-prosecutor's assertion that we failed even to address their core claim about Tu Po Chue. They described their core claim as being that Nguyen Chia participated in a joint criminal enterprise to execute class enemies and all those opposed to the CPK. In fact, we showed the Chamber that at worst, the CPK categorized soldiers and officials along with other groups, such as monks and intellectuals, people who were never subject to a policy of execution. The co-prosecutor's position that the CPK viewed soldiers and officials with suspicion is insufficient as a matter of law to establish our client's criminal liability. The closing order alleges that at Tu Po Chue, soldiers and officials were indiscriminately murdered en masse. And it follows that only a policy that required executions of soldiers and officials en masse is of any relevance to the Chamber's deliberations. Abstract class theory without a clear link to a policy of systematic execution is plainly insufficient. Mr. President, Your Honours, it's critical to recognize here that this difference between the CPK's general suspicion of Republican officials and its supposed decision to execute those officials summarily, that this difference is exactly the subject of Heng Samrin's statement to Ben Kiernan. Heng Samrin does not say that Nguyen Chia never thought about former regime officials. He does not say that those officials were not a subject of discussion. What he says is that when the party center decided how to deal with Republican officials, they, quote, I quote him, did not say kill. Instead they said, and I quote him again, don't allow them to remain in the framework, unquote. And Mr. President, this distinction cuts straight to the ambiguity at the heart of the co-prosecutor's allegation about the CPK's treatment of so-called opponents, which is that there is simply no evidence that such people were systematically executed. That brings me, Mr. President, to my fifth point about Tu Po Chue, which is that the co-prosecutor's submissions yesterday prove that they agree with us. Because while they claim their principal submission to be that soldiers were enemy of the party, they end up saying something much narrower and much simpler. They end up saying that there was a policy to kill, and I quote, officers of a certain rank and above. Now, of course, we dispute this. But the point is that the co-prosecutors know that the vague class theory Duik claims to have read in a revolutionary flag was never intended to, and never did, translate to execution. Even they know that they cannot credibly claim that our client intended to execute soldiers and officials regardless of rank. And as we observed last week, the co-prosecutors fail even to assert that the alleged victims at Tool Portray were anything more than ordinary soldiers and civilians. Yesterday, they conceded that our client never intended to execute ordinary soldiers or civilians. Now, put together, these concessions establish that Nguyen Chia never intended the execution of the alleged victims at Tool Portray. And this alone, Mr. President, requires the Chamber to acquit Nguyen Chia of all crimes charged in connection with Tool Portray. My sixth and final point is that the co-prosecutors say nothing at all about the possibility that if any killings did take place at Tool Portray, they were constituted locally directed revenge killings. Let's not forget, Mr. President, the liberation of Pursat marked the end of a years-long bloody civil war. The alleged victims were supposedly the CPK's former opponents. Revenge killings under these circumstances are typical. Your Honours, Mr. President, my very last comments today and in this trial will concern the co-prosecutor's analysis yesterday of Rusnim's role in the CPK and the role of zone leaders more generally. Now, the critical point, and I cannot stress this enough, is that Rusnim was not a mere, quote, zone leader. He himself was a member of the Standing Committee. He himself was, according to the co-prosecutors, reasoning an equal participant in the Standing Committee's practice of democratic centralism. Now, yesterday, the co-prosecutor said that Nguyen Chia met with Rusnim every 3 months in the Northwest Zone. And our question is, so what? What could the fact that Rusnim met Nguyen Chia possibly say about the content or nature of their relationship? The co-prosecutors tell us that at one of these meetings, Nim told Nguyen Chia about the execution of Nguyen Chia's uncle, Xiu Hing. Now, Mr. President, we have trouble seeing their point. Nim did not ask our client for permission to kill Xiu Hing. He was not, as the co-prosecutors observe, afraid to tell him he had executed Xiu Hing. They asked, why would Nim tell Nguyen Chia about Xiu Hing and not about Tool Portray? And to us, Mr. President, the answer is obvious. Tool Portray was none of Nguyen Chia's concern. The death of his uncle quite obviously was. Now, the hard evidence of the relationship amongst the various members of the Standing Committee, including those who were also zone leaders, is almost completely non-existent. As we saw last week, just about the only person able to speak with any authority is Ing Sari. And he says that within Ankar, and I quote, each zone was independent. Kill as you please, do as you please. End of quote. Rosnim's flippant attitude towards Xiu Heng's execution corroborates exactly that description. The best the co-prosecutors can find in response is a small handful of telegrams purporting to show Rosnim seeking advice or guidance from the party center. They do not mention the consistent testimony that communication from the party center to the zones was limited and mainly concerned goods requested by the zones. That Nguyen Chia almost never sent telegrams to anybody. And even this a very small selection of telegrams are all in 1977 and 1978, years after Tu Portray. A period, Mr. President, of years in which Ben Keenan tells us the center's control over Northwest Zone forces was, and I quote, gradually increasing, end of quote. The only document they showed you during a time period remotely relevant to these charges showed only that information was conveyed to the party center without any request for advice or instructions delivered to the zone. The question is, why is every other document the co-prosecutors presented from a period so far from April 1975? To paraphrase the co-prosecutors, we must ask, was that a coincidence? Mr. President, Your Honors, there's only one hard reality about Rosnim. That reality is that he was ultimately purged. The co-prosecutors tell the chamber that he was purged, but for them, the story ends there. And for us, it is just the beginning. The co-prosecutors do not take the next step and tell you why Rosnim was purged. The answer is, Mr. President, he was considered a traitor. He was considered a traitor because he was deliberately acting contrary to party policy. He deliberately imposed harsh conditions in the Northwest Zone for the purpose of destabilizing the party center. Mr. President, Your Honors, the co-prosecutors have never adequately answered a simple question. And these are my last words. If Nuon Chea could so easily control Rosnim's behavior, why did they deem it necessary to use military force against him?
The President. Thank you, Counsel. The time is now appropriate for lunch adjournment. The chamber shall adjourn now and resume at 1:30 this afternoon. Security guards are now instructed to bring Mr. Kyew Sampon to the holding cell downstairs and have him return to this courtroom this afternoon before 1:30. The court is now adjourned.
សូមអញ្ជើញក្រៅចូល